Did everybody have a good break? So our next speaker is Mr. Cliff Smith. He's an ethical hacker at Parameter and master of all things. If you noticed registration went a lot smoother this morning, it's because of what he did. So let's give Cliff a round of applause for registration this morning. Cliff Smith is a retired lawyer. As you can see by his age, he got tired of it, became a hacker. And I'm sure a lot of you have heard the rumors, and they are true. Nobody who has spent the night in his basement has ever made it out alive. So, without further ado, Mr. Cliff Smith.
Thank you so much for that, Dan. I really appreciate that intro. Like Dan said, my name's Cliff Smith, and we're here to talk about the General Data Protection Regulation, the GDPR, the new reg in the EU. How many people have at least a basic passing familiarity with this regulation? I'm seeing a couple double hands up. Keep your hand up if you don't know why we're talking about it in the US, you don't know why it matters, and you think it's dumb that we're having this conversation. You all are my target audience right now. All right. We will fix that by the end of this hour. I have a couple confessions to make before we go any farther, and no, they don't have anything to do with people spending the night in my basement, Dan. Thank you. I haven't updated these slides in about 36 hours. Some of this information might already be out of date. There is pending litigation that is going to change a lot of things. And it's stuff, I'm going to give you some pointers at the end on what to follow and what to look for. My other confession is I called this talk originally, The Sky Isn't Falling, but the Earth May Be Shifting. And the more research I did on this regulation, the less confident I got in that title. A lot is going to change. A lot. Even for the people in this room. So, like Dan said, I am an ethical hacker at Parameter Security. I am a professional amateur at all the things. I am uncle to that little goober right there. I am an AppSec guy. I'm a pen tester. And I am a lawyer. I am still barred. So since I'm going to be talking about a legal issue, there's something else I have to share with you. The following information is not legal advice and not intended to be relied upon as such. The following disclosure is required by the State Bar of Missouri. The choice of lawyers and important decisions should not be based solely upon advertisements. Okay, that being said, thank you. That being said, you should be careful about taking any lawyer's advice, and you should be seeking second opinions about this stuff when we get to it. Anyway, so we're going to start with some introductory material. I'd like to contextualize the GDPR against the backdrop of data protection law in the US. GDPR is coming to our shores. We'll talk about why in a moment. We'll do hopefully a relatively quick tour of the regulation, talk about its content. This is not a compliance talk. Hopefully everyone in here will at least have some introductory, basic level understanding of what you need to do to get compliant with GDPR, but this is not a compliance talk. This is about how this regulation is going to change the way we do business, potentially, in Infosec and in IT. And then after we do that tour, we're actually going to drill down on some of those catch-22s, on some of the big issues that are really going to have a major impact. So, if you are only basically generally familiar with GDPR, there's one thing you probably know about it. What happened to your inbox 13 days ago? Everybody got them. Did you see the memes? There were memes about Ouija boards. Someone photoshopped a video of Super Mario 64 to put a privacy policy update inside the castle. Jokes about opening bananas and finding privacy policy updates. My personal favorite is this one. This is a guy who woke up one morning, stumbled into his kitchen, and found a GDPR privacy policy update on his fridge. Yeah, the box that keeps his food cold had to update its privacy policy. And if you look real closely, you'll see that we know that the guy at least wears underwear when he sleeps, thanks to the reflection in the fridge door. So that's also lovely. I honestly think it's a little bit unfortunate that this is what most of the general public knows about GDPR. Yes, there are things that need to go in your privacy policy. There are disclosures. There are I's to dot and T's to cross. There are plenty of things that are fodder for your lawyers and all the fine print and the paperwork. I don't care about those things. Not right now. Because that's not what this type of conversation is for, and nobody's going to walk away and update their privacy policy based on what you hear during, a conversation at a con like this. It is the bigger changes that are going to change what else we do. Here's the core reason why we should all care. As we know, This regulation went into effect 13 days ago, May 25th of 2018. It has extraterritorial applicability. Even if you never set foot inside one of the 28 countries of the European Union, you could still be under its thumb. Is the audio okay? Are you losing me when I turn my head? A little bit? Okay. So the other factor that makes the scope of this regulation very broad is that processing is defined extremely broadly. If you are in possession, if you are putting your hands on, if you are touching PII, then you have GDPR compliance burden, and you need to be following what the regulation says. The fines for serious violations of the regulation can be 20 million euro, or 4% of your worldwide turnover. How many companies in here have less than 20 million euro profit per year and is willing to admit it? Less than 4% profit margin. If Walmart's here, or any retail companies are here, yeah, you have less than 4% profit margin. For everyone that applies to, the GDPR gives the regulatory authorities the right to issue the death penalty against your company if you get a maximum fine. That's big stuff. And perhaps most importantly, the GDPR is not just a privacy regulation. That P does not stand for privacy. It stands for protection. This is an Infosec regulation. Everybody know what the letters CIA stand for? Confidentiality, integrity, and availability. Those three words appear in that order in GDPR. They care about your information security program, not just your privacy practices. So now let's talk just briefly about U.S. data protection law. We all know that there are industry-specific regulations, HIPAA, financial regulation. But there's the PCI DSS if you're processing credit cards. But for those of us who are not in a quote-unquote regulated industry, we have just a mishmash of different legal theories that could determine what our obligations are according to the law. Information security has been shoehorned into a bunch of other different legal theories. The FTC Act, the Federal Trade Commission statute, State Merchandising Practices Act, statutes that have general provisions about unfair or deceptive trade practices. There have been Infosec lawsuits related to data breaches and bad security practices under those statutes. Makers of IP cameras have been sued for bad security, default credentials, not using SSL, all the standard stuff that the other speakers will be talking about and that you probably already know. Those mistakes have resulted in FTC and Merchandising Practices Act liability. My personal favorite, though, is tort law, common law negligence, our general duty of care. And the reason why I find this one fascinating is that the law of negligence is the same body of law that we rely on if we have to sue somebody over a car wreck, if we have to sue somebody for negligently operating a cherry picker at a construction site. And I find this fascinating for two reasons. First of all, by recognizing a common law negligence duty to secure your systems, the courts are basically recognizing that when you take possession of someone else's data, you automatically take on a responsibility, a legally enforceable responsibility, to exercise due care when managing that data, and a responsibility to exercise due care in selling other people's systems that they're going to use to secure their data, such as an IP camera or a router. The second reason I find it fascinating, if the courts are going to recognize this duty, recognize this negligence cause of action, this type of lawsuit you can bring, they're going to have to develop a standard for when you've broken the standard of care. They're going to have to develop a set of rules in common law fashion through judge-made law for when someone can be held liable or not. And you can probably guess what the upshot of this is. About 4 weeks ago, I was at a continuing legal education seminar in Branson, Missouri, the hillbilly Las Vegas, as we Missourians call it. And I was there to see Charlie Pride, actually, a few years ago. Great concert. But anyway, there were three of us, all of us information security folk. We were asked the question at the end, okay, what is the standard of care? What do we as a law firm need to do, and what do our clients need to do to not get sued if we have a data breach? Our answer was a big fat one of these. There were three of us, and we all gave three different answers. I emphasized the GDPR's answer, which is security by design and privacy by design and default. We'll talk more about that later. But since GDPR is coming to our shores, we may soon have a generally applicable framework under which security and data protection obligations can be evaluated. a basis for which all of these broad and important questions can be answered. All right. So let's talk a bit about GDPR. It is the General Data Protection Regulation, as we said. It became effective 13 days ago. There was a 2-year transitional period. There were plenty of news articles about it, but I think now folks are realizing that not enough prep work was done during that 2-year period, to say the least. It replaced an old data protection directive, an old EU regulation that had some similar content, but a lot of it is very different. I mention the Article 29 Working Party because if you want to know what the meaning of any provision in GDPR is, you go to the documents published by the Article 29 Working Party, basically an administrative body that issues advisory opinions about what the regulation means. And the successor to that group is called the European Data Protection Board. GDPR is also a top-down regulation. It does not say, use this block cipher in your SSL configuration, or remove these default passwords or default accounts from your network switches. It's going to flow from first principles. The scope of the GDPR. Now, this is the section where we're going to have to get a little bit nitty-gritty, and I've authorized Becky to throw things at me if I get too legal or go on any lawyer nerd rants. And I trust her to uphold that responsibility. So, the subject matter scope, there are 2 different halves of the scope of this regulation, and you have to fall within both. The subject matter is basically, like we said, everything that involves you touching PII. It's processing of personal data. Processing includes collection, recording, storage, retrieval, use, disclosure, and destruction. That's everything. If you've got it on your hard drive, you're processing it. There is another requirement that the data has to be either processed partly through automated means, or it has to form a filing system. A filing system is anything you can query. Carlos, do you think you could query a text file for me? Anybody ever written a regular expression before? Yeah. Find me a piece of a data store that is not queryable by a skilled operator, and, I'll eat your hat or whatever you want. Personal data. So personal data, in order to qualify, it's basically a common sense definition of PII, but you have to have an identifier or other factors sufficient to identify the subject. So a name would work, an email address would work, a username would work. An IP or a unique cookie is specifically sufficient. So you have PII if you've got a cookie that can be used to track somebody, a cookie that's something more detailed than, I want the font to be Times New Roman on this website, the way that, Tim Berners-Lee envisioned cookies to be used, before we were even using cookies for authentication. There are also special categories of data, types of data that are particularly sensitive, involving your political beliefs, your healthcare, biometrics, etc. And there are a couple more detailed requirements for those types of data. The territorial scope. Obviously, if you're a company that sits in the EU, you have an office in the EU, you're under its scope. There are basically 2 ways that you can be under the scope of the EU if you're a US company. If you sell to the EU, or if you monitor EU behavior, the behavior of EU residents. So I have to laugh a little bit when I think about this first one, goods or services being offered to EU residents, because it's a standard that the standard is defined as, do you envisage selling products or services to EU residents? And we look at things like what's on your website. Do you have content, for example, in Belgian? Are you trying to sell to Belgians? Do you accept the euro in your payment systems on your website? Do you peddle your wares by saying that you have a lot of companies in the EU who are your clients? These kinds of standards, they exist in several places in US law. They're messy. And it's a rough go to not even know if you are subject to a sweeping regulation like GDPR. For practical reasons, folks are going to have to be conservative with that. Merely having a website that is accessible by people in the EU is not sufficient to bring you within GDPR's scope. But the regulatory authorities are going to look at what you're doing and who you're trying to target with your marketing materials. And remember also that if you subcontract for somebody in the EU, they're going to have to incorporate contract terms that basically apply the GDPR to you anyway. So if you're selling business to customer to the EU, or you're selling business to the EU. That, in fact, would probably make you a processor. This is the last really nitty-gritty technical thing, lawyerly technical thing we're going to have to talk about. A controller is basically the decision maker, the data owner, so to speak, in SysP or information management talk. The processor is a subcontractor who stores the data. The processor might be Rackspace, who hosts the data. It might be Cambridge Analytica, for a recent example, who process and analyze the data for you. It might be any other analytics company you sell to. It might be Iron Mountain. If some other company is storing backups for you, they might be a processor as well. Most of the rights that data subjects have under this regulation are against the controller. So if they're going to assert these rights, like the one you might all have heard of, the right to be forgotten, yeah, that is a right you assert against the controller. So the processor's role is more to facilitate compliance and give the controller tools that can be used to meet the requirements of the regulation. If you look up AWS's GDPR guide, it's basically, here are the infrastructure services we have, and here are the ways you can use them to support your own privacy practices and security program. All right, general principles. Again, this is a top-down regulation. We start with lawfulness, fairness, and transparency. All very important. Purpose limitation. That is another big theme in GDPR. Why are you collecting this data, and why are you processing it in the way you are? And that is a way, we're going to talk about examples of good and quote-unquote evil companies, because we know that's a technical term, obviously. Companies using data for evil purposes, perhaps. And the purpose limitation section is where a lot of those supposedly evil companies are going to run aground of GDPR, because they're going to try to use data for purposes for which it was not intended. How many people in here work in an IT shop or have a home where there's a closet or a box or a bucket full of old computers or other parts that get repurposed? Dave, Parameter has that? We've been having conversations about our closet like that a lot this week. You repurpose them ad hoc for whatever need arises on a given day, right? That is exactly what GDPR prohibits you to do with personal data. You cannot collect information for analytics purposes on your website and then use it for research for people's political opinions on the next day. You have to, if you want to change the purpose for which you're processing data, you have to go back to the beginning and re-justify it, basically. Data minimization. Don't store anything you don't need and that is not necessary for the purpose for which you were originally processing it. The data has to be accurate, much like with a credit report. The data subject is going to have a right to correct your information. And while they dispute the accuracy of the information, they can put the kibosh on your processing systems. They can say, don't process my data until you've gotten this corrected. Data retention, you have to have data retention policies. You have to have rules about how long you're keeping your data. The CIA triad, security, is a requirement. Your processing systems must be secure. You must be able to demonstrate compliance. How many people have undergone a PCI audit before? How many of you had all of the documents you needed for that PCI audit ready to go when the auditor walked in the door? Nobody, right? You have to be prepared for an audit, and we're going to talk a bit about that more, but you're going to need to be documenting your security decision-making as you go. That's something we should all be doing anyway, but it can get you into trouble under GDPR if you don't do it. Again, protection by design and by default. These principles about protection apply both during the operational phase of your system and during the design phase. So you have to be able to document that you designed the systems with privacy in mind and that you're operating those systems in accordance with the relevant privacy rules and principles. All right. Lawfulness of processing is the first one we're going to dip into, and everything else flows from here. There are 6 bases in the regulation that can be used to justify processing. 3 of them matter for most of the people in this room. The first one is consent. If we get the data subject's authorization to do something, we can do it. Consent is a much more detailed model of consent than the one that exists under U.S. law for most purposes. We will talk about that. That's going to be one of the big issues, and that's what one of the pending lawsuits is about. If you have legitimate interests for which the data processing is necessary, then you can process it. That basis is the one on which we sneak in things that we need to be able to do as a business that has an IT shop, or the things that we need to be able to do in order to stay secure. The third one is stuff that we have to do just to serve our own customer. You can't go to a doctor and not tell them your medical history. You can't go to a doctor for a prescription and not tell them what other medication you're taking. So you don't need separate authorization or a separate basis to get and process that information from your data subject. Again, the special categories data, the sensitive stuff, you have to either get explicit consent, which calls out this particular category, or you have to have the data subject having made the information public already. Like if you post on Facebook, I'm a member of the party, then you can process that data because they've made it public. The first two of these, consent and legitimate interest, will be doing most of the work. So we have a list of, you can call them enumerated rights, you can call them on-demand rights. These are rights that the data subject can assert for the most part at any given time. There are some prerequisites. Any Unix system admins out there? Linux folk? Okay, a few. If you want to think of them using some Linux system tools, maybe that helps, maybe it doesn't. All right. So the right of access, you have to be able to tell the data subject what you have about them. What do you know about me? Like the Facebook data dump or the Google Drive data download, except it has to be complete and accurate. Unlike what we suspect, Facebook is not telling us about what they know about us. Right to rectification, again, if there's information they have that is incorrect about you, you can fix it. You have the right to be forgotten. You have the right to opt out of automated decision making. And we're going to come back to that one because I think that right borders on a nullity, borders on nothing, a useless right because of some issues in the way they've drafted that right. The right to portability, you can go to another data processor, to another firm, depending on what it is this company's doing for you or with your data. You can send it to somebody else and they have to provide it for you in a machine-readable format. You have the right to restrict processing under certain circumstances. You can tell a data processor or controller rather, don't change my data, don't do any more processing with it until a certain specification, a certain condition has been met. And you can also object to a claim of legitimate interest. So this is kind of the messy part of the legitimate interest standard. If you're processing my data on a claim of legitimate interest, which you do have to tell me that that's how you're justifying what you're doing, I can say, I object to that claim, I think it's nonsense, I don't want it done. You have to come back to me and say that here is my claim of a compelling legitimate interest and document it for me. And at that point, once you've given me that information, you can continue. If I'm going to fight you further on that, I actually have to go to the regulatory authorities and file a complaint. So this is a lot of the high-profile stuff. This is the stuff that's gotten a lot of headlines, especially the right to be forgotten. And there are some catch-22s in there. We'll talk about those in a minute. Security requirements, confidentiality, integrity, availability, and resilience of processing systems. You must have appropriate technical and organizational measures. You have to have a disaster recovery system. If you don't have a working disaster recovery system, you are in violation of GDPR if you're subject to it. You have to have a process for regular testing, assessing, and evaluating of security measures. What does that sound like? Painful, yeah, probably. But it sounds like you have to have some kind of regular security assessment. You have to have either an in-house red team or you have to hire a pen tester every now and then. Now, I'm a pen tester. I like having more business, but it is also not clear exactly how often you have to have these assessments, how detailed they have to be, what has to be covered in the assessment. Do we have to do social awareness training? Or security awareness training? Do we have to do phishing exercises with our employees? There are a lot of things that are discussed in detail in the GDPR. It's 99 articles and 175 recitals of principle before those articles. The whole PDF is 88 pages long, from the, Lex Europa, whatever the printing offices of the EU. There's a lot of detail about a lot of things. There's a lot of discussion of consent. There's not a lot of discussion of security requirements. So one big question in my mind, let's say I have never gotten breached, or at least nobody can prove that I got breached as a data controller or processor. Nobody can prove that data has been stolen from me. But an auditor notices that I have some really bad security practices. I have no disaster recovery whatsoever. I have no systems, no processes, no plans whatsoever to prevent unauthorized alteration of my data. I have no integrity protection at all. Can I be fined? Can I be fined? I see a nodding head. In the US, usually there's an actual injury requirement. Usually you can't be sued or you can't be gone after unless someone has actually been concretely hurt by it. And quite a few lawsuits have failed on that basis because plaintiffs couldn't prove that either they were injured concretely or that the data breach in question was what let, for example, the identity theft happen. They couldn't prove that they stole my information from Yahoo's database or .com's database. I think, based on my reading of this regulation, there's a lot of discussion of things that are likely to result in a high risk to the rights and freedoms of data subjects. Is there going to be a risk to these things that you're supposed to be free from as a data subject? Clearly, bad security practices create a risk to data subjects' rights and freedoms. Rights to privacy, rights to be free of inaccurate information floating around the web, the dark web, wherever it might be. I think it's very clear that the regulatory authorities are going to be willing, in certain circumstances, to fine people, or at least enter injunctions and other court orders against companies who have bad security practices, even though they can't prove they've been breached. Nobody can prove you've been breached. There is a breach notification section of GDPR. It's pretty typical. One of the actual nice things about it is there's something of a vague standard for notification to the data subject. That does not apply if you have encryption at rest for the data that makes the intruder unable to read it. That makes sense, right? But if you have engaged in performed some kind of incident response that makes the high risk to the data subject no longer likely to materialize, then the notification doesn't apply. So you have to report to the supervisory authority, to the regulators, no matter what. You only have to notify the data subject if the breach is likely to result in a high risk to the rights and freedoms of the data subject. First of all, what does that mean? What is a high risk? Well, the EU courts and in true common law fashion will help us figure that out through litigation. But I can get out of the data breach, the data subject notification rule if my incident response actions have made that high risk to the data subject's rights no longer likely to materialize. That's a little vague. The nice thing about this is, since I have to report to the supervisory authority first, they will at least get a chance to tell me I need to tell the data subject. So the possibility that all but eliminates is that I think I'm safe and don't have to notify the data subject because of my incident response. And then I get burned later on the back end because the regulator says, no, you needed to notify the data subject. They will at least be able to tell you that in advance, and you can fight that out with the regulator beforehand instead of banking on the judgment you've made and risking getting, burned all to holy hell for it. This security section is possibly the most impactful part of this regulation, depending on how far the regulatory authorities go in imposing specific requirements and in finding violations. This could change everything, right? So let's drill down a little bit. I think of this as the Billy Mays section, but wait, there's more. All right, the first section. I apologize for that. That creates some confusion that is going to create some very juicy areas for lawyers to do their work in. We all hate lawyers. Is the legitimate interest definition. Now, the regulation says we're supposed to consider the reasonable expectations of the data subject. What is the data subject expecting the controller or processor to do based on our relationship? Now, I have no problem with the reasonable expectations of a citizen being used to determine the content of a fundamental right. That's how Fourth Amendment law works in the U.S. The law of search and seizure. It's about what expectations you manifest, what types of information or areas you try to keep private, and whether the courts are willing to recognize that expectation as reasonable or legitimate. That makes sense. Law enforcement has been around since this country has been around. Search and seizures have been around that long. Problem is, this regulation, especially with fools like me jumping and hooting and hollering on stage saying it's going to change everything, I don't think people know what to expect anymore. This is more rapidly changing than almost any other type of relationship that the average person has with one of their vendors. Your relationship with Google or Amazon or Facebook or one of the data brokers who has all of your information and is selling it to the highest bidder or however they do that business. So I think what this basically means is that the courts are going to have to take, or the regulators, if they promulgate more regulations and more detail on this, are going to have to take a very active role on defining what reasonable expectations are. So this is basically a rubric or a template for figuring out exactly what legitimate interests are. One thing that you can always do, you can always perform processing that is strictly necessary for preventing fraud. So, for example, comparing, tracking credit card payments that fail, tracking false user information, or perhaps even tracking shipping of a product to a known dead drop address. Maybe that's necessary for preventing fraud. Who knows? I don't work in retail. But processing activities that are strictly necessary and proportionate for security are also legitimate interests. Now, let's pause for a minute on that phrase. Strictly necessary and proportionate. So you're going to have to justify your security measures based on the size of the threat and the magnitude and the likelihood of the threat materializing. Before, we had to justify that we were doing enough to protect the confidentiality, integrity, availability, and resilience of our processing systems. So we have to have a security program, but we're going to have to justify it in both directions. We can't do too little to protect the security of our systems, but we can't do too much so that we're processing personal information that is not proportionate to our security needs. That's tough. I think it's good to keep in mind that all regulation, I'm not here to talk about politics, but all regulation depends on the people who implement it and enforce it being good, skilled, honest, and knowledgeable. That's always been the case. So we will see how these work. Now, direct marketing, this is a messy element of legitimate interest. Direct marketing may be a legitimate interest. However, your right to object to processing is absolute when the processing is done for direct marketing purposes. You can tell anybody, anywhere, anytime, stop processing my data for direct marketing, no matter how they got it from you. You have an absolute right to put the kibosh on that. So I think the way I think of this, perhaps Amazon has a legitimate interest in showing you products on the front page that you're going to like. Amazon has millions of products, and that's a form of direct marketing to a customer that they have an existing relationship with. But let's think about the creepy flashlight app that asks for 17 permissions in Android, which are not sufficient to get your consent under GDPR for processing that data, just by the way. But you know it's collecting all kinds of information about you and probably selling it to people according to their privacy policy. That is the type of direct marketing. Even if they're using that information to show you ads inside that flashlight app, even if they're not actually selling it to anybody, I think that is probably the kind of direct marketing that is less likely to be a legitimate interest. Again, we'll have to wait for other lawmakers to look at this. There's a balancing test at the end of the day. If I raise that objection against your processing of my data, you have to show a compelling legitimate interest that overrides my rights and freedoms. This is the beginning of a new area of law. That's basically what it is. Let's dive into consent. Anybody remember the video that went around a few years ago, Consent is Like a Cup of Tea? So the model of consent under existing U.S. law for purposes of data protection is pretty simple. You can consent when you want, and it can be consideration for a contract. This model of consent is very different. It's much more like the cup of tea model. So a lot of this definition, the text is not all that groundbreaking. Freely given, specific, informed, affirmative, and unambiguous. It has to also be granular. So what that means is, first of all, the reason why a lot of those emails you got a couple weeks ago were asking you to opt in, inaction can no longer be a manifestation of consent. You can no longer have pre-tick checkboxes. You can no longer have systems that say, we're going to do this and we're going to assume you consent to it unless you tell us no. An affirmative act must be used to get consent. Granularity means that every purpose for which someone processes your data, if you're basing it on consent, they need separate consent for each purpose. So you have to put right out there what are the different purposes for which this data is being processed when you get someone's consent. And you have to have separate checkboxes for each one. It has to be as easy to withdraw consent as it is to give consent. So if you give consent by checking some boxes and clicking OK, you have to withdraw consent the same way, by unchecking those boxes or doing something similarly easy. Things get a little bit more interesting when we drill down on the freely given element. Does anybody use any service where, or it could be software, could be social media, could be whatever, where your consent to personal data processing is a condition of you using the service? Yeah. A service conditioned on consent of a processing unrelated to that service. So in other words, if I'm going to sell you a service, an app, a website, whatever, and I ask you for the right to process personal data that I don't have to deliver you that service or make that app work, the courts are going to look extremely skeptically at that arrangement. In fact, it's going to be presumed that your consent was not freely given. The lack of detriment element that you see here, I can't even, if you decide to withdraw your consent later or just say no up front and deny consent, I still have to give you the service I was planning to give you. So this is a referendum on an entire business model. Who has the creepy flashlight app on their phone? I still have one. I don't know if modern phones, I have a Galaxy S5 Sport. It doesn't have a built-in flashlight, so maybe newer Androids have one built in so you don't have to go to the Play Store to download one. I'm behind the times. But anyway, what do you think the consent form is going to have to look like for that app? I submit to you it's going to have to look like this. They are going to have to ask you specifically, read my email address, record my microphone, track my location, track my processing and memory usage. And you're going to have to specify one by one, I want to use this to develop mobile hardware. If it's my own, if I'm trying to fix bugs in my own software, that's probably a legitimate interest, right? That's part of being in business and selling software. We'll come back to logs in a minute. But if I'm using it to do research on hardware, if Samsung gives you the stupid game on your phone, the crossword puzzle or the whatever, and they're using it to develop hardware, that's different. If they're just trying to figure out how many people between the ages of 18 and 24 are in my zip code, they have to get separate consent for demographic research. They have to get separate consent to guess what your political affiliation is. You going to check those boxes? I'm not. I'll delete the app too if it's actually put in my face like that. And sure enough, there's already litigation related to consent. It was filed on May 25th, 2018, the day that the regulation went into effect. There's an advocacy organization called NOYB.EU. What does NOYB stand for? Exactly. They have sued Google and Facebook over the Android operating system, Instagram, Facebook, and WhatsApp. Those are some big players in this space. And the core of the lawsuits, the claim is, you're forcing me to give consent. That's not freely given. The options that the user had in the screenshots shown in the petition, the complaint, are to agree or shut the device off, to agree or delete your account. You know what the max fines are for these companies if they get hit with 4% of worldwide turnover? We're in 10 figures. We are in the billions of dollars. Holy wow. If the GDPR means what it says, Google and Facebook lose these lawsuits. If the words printed in black and white mean what they say, they lose. I'm sorry, that's not an opinion. That's just reading the text of the regulation. I don't know what these companies are planning to do. I don't know what tricks they have up their sleeve. I don't know what settlement negotiations they're going to do. I don't know how much their lawyers are being paid. I'll bet you they're over $1,000 an hour for some of these. But anybody remember Bruce Schneier being quoted all the time as saying surveillance is the business model of the internet? He's absolutely right. And some of the worst implementations of that business model are now under direct referendum, direct challenge. Follow this lawsuit. It's going to change everything. And this is particularly what I meant when I said these slides could already be outdated. All right, so slightly less exciting, the right of erasure, the right to be forgotten. I think of it as a way to enforce the data processing rules, is that you have the ability to erase the data stored about you if it somehow conflicts with your rights. Specifically, if you withdraw consent. If processing was based on your consent and you later withdraw that consent, you can click the delete button. You can type RM*FR, so to speak. If the data is no longer necessary. Now remember, we're not supposed to be storing or processing data after we don't need it anymore. But if that time comes, the data subject can make you get rid of it using this right of erasure. If your data has been processed unlawfully, that's one of my favorites. There's a penalty for breaking the law. If you do something unlawful with the data subject can make you erase it, even if, going forward, you have consent or a legitimate basis. If you make a mistake at some point in the past, that mistake can result in you losing the data. There's an exception for freedom of expression and information. Most obvious example, do you think a holder of public office can tell the National Enquirer or the New York Times or randomblogger.com to delete all personal information they have about them? Nah. The free press is a clear example of an institution or a public interest that is going to be protected by this exception right here. There are two questions that always come up when we talk about the right of erasure. First of all, what about backups? Do I have to drive to Iron Mountain and erase my magnetic tapes? Because you're all using magnetic tape, right, for your backup? Awesome. Circa 1996 technology. Do I have to go and erase the data from my backups as soon as I get an erasure request? And second, do I have to keep a record of the request? When I do security awareness training, there's an exercise I like to do. When I introduce CIA, confidentiality, integrity, availability, to non-technical employees, I like to ask them to come up with a situation where each one of those being jeopardized could result in someone's life being in immediate danger. It's not too hard to come up with examples, right? You know, the net, that 1993 movie, Dennis Miller, someone edited his medical record so it made it look like he was a diabetic. They pump him full of insulin and he dies. Can you think of examples of data processors where if someone wants your data erased, the mere fact that you requested erasure is just as damning as the content of the data that they got rid of? Yeah, plenty of them. And one of these actually has a fairly good answer. So there's a blogger named Stefan Estevez. I reached out to him, didn't hear back from him, but he says he actually asked the French regulatory authority about this, about the backup issue. And what they said is you have to erase it from your production systems, but you don't have to drive to Iron Mountain. What you do have to do is your restoration systems, your restoration routines, have to have a filter. You have to be able to filter out the data subjects who've requested erasure. Now, your backups are supposed to expire, right, at some point. So you're supposed to be able to tell the data subject, my offsite backups of your data are going to be gone after 90 days, 90 years, whatever it might be that you can justify. But you have to be prepared to not restore that person's data into your production systems after they've made an erasure request. And you have to, of course, tell them in response to the request, here's what I'm going to do, right? You have to keep them informed. Transparency, right? In that situation, you have to keep a record of the erasure at least that long, right? If you've got the data in an offsite backup. Here are my personal recommendations. And again, I ain't your lawyer. So I think it makes sense to keep an anonymized and only numeric statistical record of each erasure. So say someone requested erasure, they gave me a name, or they gave me an IP address or a username. I went and I found umpteen records in this database, I deleted them. Umpteen records in this database, I deleted them. Subject was notified that the erasure was completed on this date, right? So that will prepare you to respond to an audit. If you have no records of erasure whatsoever, I could easily see the regulatory authority saying, wait a minute, I just have to take your word for it that you're erasing this stuff? But the other half of your accountability here is that you can theoretically just run that cat command, run that disclosure request. Try to inform that if the data subject later comes back and says, I don't think you erased my data, you can then say, well, here, look, here's what I'm disclosing about you that I have. It's nothing. Clearly, I erased your data. So the absence of those records from your production systems helps provide evidence of erasure in a specific case. So that's the approach I would use. Automated decision making. So you have the right to opt out of it. Here's the problem I have with it. All right. So yeah, there are exceptions, explicit consent if it's necessary for the performance of a contract, etc. However, What you get is the right to human intervention. If you're a data subject who doesn't want a credit report or a credit decision made on automated means, for example. To be more specific, the type of decision making we're talking about is a decision that has legal effects or similar consequences for your life. For example, a credit decision or membership in, getting your CISP or something like that, or character and fitness when you're taking the bar to try to become a licensed attorney. I would have the right to opt out, if GDPR applied. I'd have the right to opt out of automated decision making on my character and fitness application, which is my background check and my, how many bodies do you have in your basement thing. The regulation does not say that you're free of automated analysis. So what's to stop me as a data processor from running the same algorithm, using the same processing system, and just having a human look at the result and go, looks good to me, check. So I think the regulatory authorities could demand to see some record of manual analysis, but I'm not sure how thick that piece of paper has to be, so to speak. I'm not sure how much detail you're going to have to put down. So it's not clear to me how valuable this right is, honestly. And the courts will tell us. Analytics and logs. So this is a big one. You have more freedom if you're able to justify what you're doing on a legitimate interest than on consent. A legitimate interest, you still have to disclose things, but that can be in your privacy policy. You don't have to do the granular consent business. I think it's clear that there are security justifications for access and error logs in most cases if you're running something like App Sensor or an IDS or something like that. I think there's a clear legitimate interest in detecting attacks, and if I'm wrong on that, then, knock me over with the feather. For analytics, for example, Google Analytics, there will be usability justifications for that. If you see people falling out of a sales funnel, or whatever they call it in Google Analytics, if you see people dropping off of your site on one particular page, that could be usability information. I think there's a justification for that. But remember the purpose limitation and minimization rule. Don't collect data you don't need for the purposes. You have to write down why you need this data and what you're doing with it and justify the fact that you're using and collecting this data. One example of a good feature that can help you in this area is the IP anonymization. I think what it does in Google Analytics is it just drops off the fourth octet. Now, problem with that is in a lot of organizations, in a lot of situations, dropping the fourth octet will tell you a lot about where that person's coming from. It might narrow them down to a single company. It might narrow them down to 2 or 3 companies, depending on how your ISP's network is structured. I don't think this is time to panic over analytics and logs. Cookies, there are actually people doing this, where not only do you see here's our privacy policy, click OK to accept, they're actually showing you, do you want to opt in to functional cookies, cookies that make other features of our site work, or do you want to stay opted out? There are companies that are asking you to check whether you are okay being part of A/B testing. I don't know that you have to go this far. I think there's a very good argument that there's a legitimate interest to justify A/B testing. We have to make our product usable. That's part of being in business. And if you have a legitimate interest, you don't need consent. But there are people doing this. There are people being this conservative. So, I don't know. Certification bodies. This is potentially one of the more impactful sections of this regulation, and I think it has a big weakness. So, certification marks, for example, Info Trust Incorporated Privacy Certified, that type of mark, and codes of conduct for certain industries. The regulation actively encourages the industry to develop those. And there are mechanisms for certifying them. So for certifying a code of conduct for example, the cloud industry, the cloud storage industry. That's one of the big ones that's in development. In fact, there are at least 2 codes of conduct I've read about that are being developed. None of them are certified yet, to my knowledge. So if I'm in a certain industry that has a code of conduct, I can use that code of conduct for guidance on what practices I need to have in place in order to comply with GDPR. The regulation reads, honestly, like the EU doesn't want to be in the business of saying you can't use MD5 for uniqueness testing anymore. You can't use, SSL certificates signed with MD5, HMAX or whatever. I think they want to push that to these codes of conduct, the bodies that manage these codes of conduct, and the organizations that manage these certification marks. There are requirements that the organizations that get accredited to give out these marks or manage these codes of conduct, they have to watch you, and they have to be prepared to take your certification away from you if you screw up. So this is a pretty potentially big apparatus that could be built to manage GDPR compliance and security. The big downfall, it's not a safe harbor. If I am in an industry with a code of conduct and I comply with it, I'm not guaranteed to be in compliance with GDPR. So in other words, the regulatory authorities can still come back and say, you weren't doing X, Y, Z, even if you were complying with your own code of conduct. I think that's a problem. I think that's a weakness, and I think it is going to discourage development of these standards. And it is going to minimize their value, because you're still going to have companies, even if you're a cloud service provider that has a cloud service provider code of conduct, they are still going to have to ask the question, but what else might I have to do? To do a little CYA, what else might I need to do to reduce my risk of getting hit with the fine? So I honestly hope they fix this one. I wish it were a safe harbor. Enforcement against U.S. companies, there is a bit of complication, thorniness here. This is international law. I am not an expert on international law, but it's very, very different from domestic law. There's not a Republican government, a legislature, an executive branch and a judiciary that is all backed by the same government in international law, say between the EU and the US. We have no specific enforcement mechanism for GDPR fines against US companies. That mechanism doesn't exist. There may be legal justifications, even if an EU court issues a fine against a US company, there may be legal doctrines that allow a U.S. court to say, no, we're not going to enforce that. That basically goes against our values too much. We think there are fundamental fairness issues here that would prevent us from enforcing this fine against our U.S. company. Keep in mind, though, that if a judgment is entered against you in an EU court and you have customers in the EU, they could probably garnish those payments. So they go after people who owe you money and say, nope, that person owes a fine to the regulatory authorities. You're paying me now. You're not paying, USA Inc. or whatever they're called. This is a big unresolved issue. We are going to see litigation about this. We're going to see examples, I predict, of U.S. companies with no establishment in the EU having fines issued against them and people chasing those companies down. And it will be, from a lawyer's perspective, it is going to be exciting and interesting. A lot of lawyers, lawyer geeks, law professors, people who find the law interesting, hate it when companies settle because we don't get a decision. We don't get that juicy appellate opinion to read and dissect and learn about. So this is exactly what that kind of lawyer loves. Here is just a small sampling of the unresolved issues here. What is the scope of your legitimate interest? There are multiple questions in that area. This whole notion of forced consent or conditional consent. How is that big old NOYB lawsuit going to turn out, and how much are Google and Facebook going to lose when they lose that lawsuit? All of the international issues, the extraterritorial issues, the content of the security requirements. Are we going to see codes of conduct developed? And like we mentioned before, is there going to be an actual injury requirement for fines for data security fails? If no one can prove that their data was stolen from your servers, can you still be fined for having terrible security? Maybe. A few pieces of general advice. Step one to complying with GDPR is always understand your data and where it comes from and why you have it. Top down. Understand everything. I mean, that's a sermon that a lot of security people preach in a lot of contexts. Everything should flow from a security program and a policy and a plan. If you don't have any policies that are GDPR conscious, that are aware of the requirements of the GDPR, that looks terrible. It's bad to be caught with your pants down. It's worse to be caught not owning a pair of pants. So at least be able to show, if you have a GDPR auditor knocking on your door, at least be able to show that you were thinking about the regulation. Document and date your security and privacy analysis and decision making. You should be able to prove. I've been working on a new server infrastructure for some subscription services for Parameter that we're working on. I can show you the security decisions that we made during the development of that system, the things we rejected, why we rejected them, and why we settled on design the way we do. You have to prove that you did that work during the design phase. All systems need to be auditable. Those enumerated rights, you have to be able to shine a light on the black box from any angle and see what's going on. Everything needs to be auditable. A mini checklist. You start with your justification. How is your processing lawful? You have to limit the purpose of your processing and limit the data that you collect. Figure out how long you're going to retain it. Disclose the appropriate things to your data subjects. Again, that's lawyer territory. Read the regulation. And have appropriate security controls. I know those are big, vague items on that checklist. What's underneath those items in the outline? I think we'll all find out together. All right, that's all.